Mary McCord, Glenn Kirshner, and Lisa Rubin are all back. Okay, Glenn, I think this is just so important for people to understand. Let's just start with the fact that this language is standard protocol. Explain more on that.
Every law enforcement agency, every law enforcement officer, when they are on an operation, whether it's executing an arrest warrant or searching a premises, they're entitled to use deadly force when to repel a deadly attack or to protect the safety and lives of others. So this was entirely routine, run of the mill, as the Attorney General and others said. But I'll tell you, Jen, the most infuriating part is when I read that 12-page filing from Jack Smith, and there were two things that really jumped out at me. One, they coordinated with Donald Trump's attorneys in advance of the execution of the search warrant. I have to tell you, I think that's a mistake, because that gives targets of an investigation an opportunity to hide evidence, to destroy evidence, to, I don't know, move boxes of classified documents from one place to another. Not only that, they executed this search warrant at a time they knew Donald Trump and his family would be out of Florida. They weren't even going to be in the state. So when Donald Trump posts that they were ready to shoot me and they endangered my family, he knows that is an extraordinarily dangerous lie to tell, because they weren't even in the state, and the FBI made sure they weren't going to be in the state. So when Steve Bannon says this was an assassination attempt, it's got to be the most incompetent assassination attempt ever, because they made sure the target wasn't even going to be on the premises. This is dangerous, violence-inducing rhetoric from Donald Trump.
And I want to spend a moment on that, because the threat, and Jack Smith references this in his filing, it's just the danger this caused. You heard Merrick Garland talk about this. And you've had all of these elected officials who know better. First of all, even if they're not lawyers, they know Trump wasn't even there at the time. That's an easy to understand fact. Right. And what the problem is that people can watch Tim Scott or watch Marjorie Taylor Greene and think that there was an assassination attempt on the former president when there clearly was not. Talk to me a little bit about the danger that this type of rhetoric and the echoing of it poses to law enforcement officials.
This is exactly why Jack Smith has sought an amendment of the conditions of Mr. Trump's release pending trial to include a condition that he not make these types of accusations and attacks. We know from, all of the cases that have been brought that attacks on judges result in threats to judges. There's a person being prosecuted for threatening Judge Tanya Chutkan here in D.C. in the January 6th related case. We know that right after the Mar-a-Lago search warrant was executed, there was an attack on the FBI field office in Cincinnati in retaliation for what the person who committed this had been, consuming as some sort of unfair raid on Mar-a-Lago. We know that prosecutors have been threatened, over emails, by voicemail, with people coming to homes. We know people have gotten doxxed. People have gotten, had false hoaxes called in about them and swatted, as they call it. So there is a track record here of people listening to false statements, not only by Donald Trump, but by people like Marjorie Taylor Greene, people like Tim Scott, and acting on them. And now this is probably the most inflammatory of all. Actually saying there was an attempted assassination, which is completely false and crazy. And what Jack Smith is rightfully concerned about is that is going to put a target on those law enforcement agents' backs.
It is so alarming. Lisa, Aileen Cannon has had moments where she's kind of exhibited some element of responsibility, other moments where she has not. What can she do here? What are the options should she want to take action?
Well, the first option for her is to do exactly what the motion asks, which is to modify Donald Trump's conditions of release. And Jen, I want to pause on that and differentiate that from your standard gag order, because the relief that the government is asking here would modify Trump's conditions of release such that if he were to violate them and make some sort of significant, imminent, and foreseeable threat to the law enforcement involved in this investigation, she could immediately revoke his release and impose conditions that would include putting him in jail or pretrial detention. So the very fact that the government is asking to modify the conditions of release and not just a standard gag order, that's a big deal. Then again, we have Judge Aileen Cannon, who has not been particularly expeditious in ruling on even the motions to dismiss in front of her. I think she sits on this for a while and then likely denies it, at which point Jack Smith can elevate this to the 11th Circuit. A denial of a request to modify conditions of release is immediately appealable in the federal system, and that's one of the reasons they likely have asked for it the way that they have.
Not particularly expeditious. That was such a good way of describing it, Lisa. Thank you all so much, Mary McCord, Glenn Kirshner, Lisa Rubin. I know you will all be working very hard explaining this to all of us all week, so I appreciate you joining me this afternoon. Christy Greenberg is the former deputy chief of the criminal division in the Southern District of New York. Anna Bauer is a courts correspondent for Lawfare. Both have been attending this trial and covering it very, very closely, I think it's fair to say, and both join me now. Christy, let's start with you. I just read a statement from Barbara McQuade, and for those who are trying to understand how all of Trump's bad behavior could impact a sentencing, and again, I always like to state we don't know what the jury's going to do. That's up to them. How do you see it? Could that impact the sentencing?
I don't think it will. As much as this judge, I think, on a personal level, probably is not a fan of Donald Trump. I think that's probably an understatement at this point. I think he has to look at certain factors for sentencing, and Donald Trump saying nasty things about the judge personally is probably not going to be a factor that the judge will look at. The judge is going to look at the seriousness of the conduct that he's, if he is convicted, that he was convicted of. He's going to look at deterrence. What is it going to take to make sure this guy doesn't offend again and do the same kind of thing? General deterrence for others. He's going to look at, as Barbara said, violations of the gag order and promoting respect for the law. But under the gag order, Donald Trump is allowed to attack the judge. He is allowed to attack the process. He's not allowed to attack jurors, witnesses. And so those violations of the gag order, absolutely, I think the judge will consider. And the lack of remorse, I think, is a general matter. Donald Trump has been fighting his case, which is his right. But once he's convicted, if he's convicted and then sentenced, a lack of remorse really is something that judges look at. So if he keeps this up, if he keeps attacking the process after a conviction, yes, I do agree that that is something the judge would look at sentencing.
What about you, Anna? I mean, not to prejudge what the outcome is going to be or any potential sentence, but you've also been covering and watching this judge closely. Anything that you're watching or anything you think in terms of consequences or repercussions of Trump's actions?
Yeah, look, I think that Christy is right that the previous gag order violations probably are something that Justice Merchan is going to take into account. He clearly took it very seriously. Trump has been held in contempt of court 10 previous times. And it's also notable as well that while Trump has recently been attacking the judge and Alvin Bragg, which he is allowed to do under the gag order, there have also been times recently at court that he's gone out and not by name, but by implication has been attacking members of Alvin Bragg's staff, which the gag order does, in fact, prohibit, specifically Matthew Colangelo, who used to work for the Department of Justice, and Trump has, by implication, suggested that there is someone from Joe Biden's DOJ who is running this trial, a seeming reference to Matthew Colangelo. However, prosecutors who have the burden, of course, of filing a motion to hold Trump in contempt have not taken the steps to file that motion. I think probably because we are coming up towards the end of this case, they want to keep things moving and don't want to, throw another wrench in the machine by bringing up another gag order violation. But I think that Justice Merchan is probably taking notice of these various public comments that Trump continues to say in apparent violation of the gag order.
So, I mean, Christy, as Anna, we're near the end here. Well, sort of. We're closer to the end than we were a few weeks ago, I think it's safe to say, of this trial at least. Tomorrow, the closing arguments start. In your view, what does the prosecution need to do and anything that you're going to be particularly watching for?
So I worked with Alvin Bragg when we were prosecutors at SDNY, and one common technique in closing arguments, it's not always done, but it's done a lot of the time, and I actually think it would be good for this case, is to really point out for the jury what is actually in dispute and what is not in dispute, so that they can really focus on the issues that are before them to decide. And in this case, there is so much for the prosecution to point to that is actually not in dispute. You know, things like AMI working with Michael Cohen to catch and kill these Karen McDougal and Stormy Daniels stories, and the planting of negative stories against Donald Trump's opponents and positive stories in favor of Donald Trump. That's something that's nobody is disputed in the case. You know, the Access Hollywood tape being a crisis for the Trump campaign, not in dispute. The fact that Michael Cohen was discussing the Karen McDougal payment with Donald Trump, that's on a recording. They can't really dispute that the recording says what it says. We heard it. And that the payments to Stormy Daniels were delayed, that Michael Cohen made those payments after having to take out a home equity line of credit on his house, and then setting up this shell company to do it, that kind of whole secret mechanism, not in dispute. The fact that Donald Trump signed 9 of the checks to Michael Cohen, and that there were invoices that were attached to those checks, not in dispute. You know, they're, I think, going to point out all of the tweets after FBI raided Michael Cohen, before saying, you know, don't flip, and then after he made comments that Donald Trump directed the payments and they were for the financial benefit of Donald Trump. Then all of a sudden the tweets that Donald Trump put out that were attacking Michael Cohen, and this, you know, the sort of the pressure campaign beforehand, and then when he flips, attacking him. All of that, there is no dispute here that that happened. And so much of that is kind of corroborating Michael Cohen's story and the stories of the other witnesses about what happened here, that these payments to Stormy Daniels were made at the direction of and the benefit of Donald Trump.
I mean, there's so many details, as Christy just outlined so well, that we've just learned, we knew, have been reiterated, and we know, or I think we can all expect, that part of the defense's strategy is going to be to continue to attack Michael Cohen's credibility. What are you going to be watching for in their closing arguments tomorrow?
Right. So I certainly think that in closing arguments, it's all coming up Cohen, so to speak, and that a big strategy here for the defense is going to be attacking Cohen's credibility on various fronts. They're going to attack his recollection. They're going to bring up this moment on cross-examination about that October 24th phone call to Keith Schiller, in which Cohen originally testified that he spoke to Trump about the Stormy Daniels hush money payment on that call. The defense, however, tried to suggest that there was another reason that Cohen could have made that call. They're also going to attack his motives. They're going to say that he's profited off of making podcast and media appearances about Trump. But beyond attacking Michael Cohen, I think that we're also going to hear a lot about causation. They're going to focus on that key element because the prosecution has to prove beyond a reasonable doubt that Trump caused these false entries in the books of the Trump Organization. And I think to that end, they're going to say that, you know, there are other people who were involved in this who were the real causes. For example, they could point to Allen Weisselberg and to the fact that Allen Weisselberg, the Trump Organization CFO, did not testify at this trial. I think that we also will hear a lot about intent to defraud, or intent to cover up the other crime. They're going to focus on the fact that it's a lot of circumstantial, not direct evidence of intent here. So those are some of the things that I'm looking for. But I do think that Cohen's credibility is going to take the forefront of the strategy for the defense in the closing arguments.
No question. Before I let you go, Christy, I just want to ask you, I mean, after the closing statement arguments, we will get jury instructions, or the jury will get instructions from the judge. What are you looking for in those, or what will be interesting to watch?
So this point that Anna made about the causation, I'm very focused on that piece in terms of the falsification of business records. We know that Donald Trump wasn't in the systems of the Trump Organization going through general ledger entries, but you can cause somebody else to make those entries, and that makes you guilty as well. If you did it indirectly, if you requested someone to do it, if you approved somebody doing it. And the prosecutors wanted an instruction saying that, well, causing somebody to do it can be done if it's a reasonably foreseeable circumstance that those business entries would be made, given that you approved kind of the reimbursement scheme as a whole. And Juan Merchan seemed very reluctant to give that instruction when they were having argument about this in court. We haven't seen the final version to know if that's in there. So that is one thing I'm going to be looking for, because there really wasn't the direct evidence that he instructed anybody to make any particular entries in terms of the general ledger or the invoices. So that is one I'm going to be looking for. If they don't get it, I suspect the prosecutors will say, well, they were working in concert with one another. And so once he gave that instruction, you know, he's essentially an accessory to this happening because he approved the general scheme. So I think they'll get around it, but it would certainly be better if they got that instruction. We'll see if they get it.
Lots of things to watch. Some different advice and views from the prosecution and defense with those jury instructions. Christy Greenberg, Anna Bower, thank you both so much for joining me on a Memorial Day. Appreciate it. Mary McCord is the former acting assistant attorney general for national security at the Justice Department. Glenn Kirshner is a former federal prosecutor. Lisa Rubin is an MSNBC legal correspondent. All of them have been following this trial very, very closely, and they join me now. So, Lisa, I'm going to start with you because you've been in that courtroom. You've been there almost every day, maybe every day. You've been covering every day. Sorry, I didn't mean to cut you short there. We know Josh Steinglass is a meticulous and organized storyteller. I mean, that's my definition, just of hearing the reporting and reading the transcript from the opening statement. What do you expect in terms of what he'll say, what's important for him to say, and how it will be structured tomorrow?
I think Josh Steinglass is finally going to put together a chronology from all the disparate pieces that we've seen so far, Jen. And we have seen testimony from so many different people and data and other documents from disparate sources, everything from phone record providers to the Trump organization itself. And so I expect that Josh Steinglass is going to take the jury through how the conspiracy was formed, how we know Donald Trump himself was not only a part of that conspiracy in a broad sense, but okayed the payment to Stormy Daniels. And then moving on to the period in which he was president, how we know that he okayed the repayment scheme that Alan Weisselberg and Michael Cohen came up with, and then executed the checks, 9 of them personally, to Michael Cohen all throughout that period. And then they're going to take us to a period beyond the point where Michael Cohen was receiving checks to all the different episodes that show what Mary and Glenn will know as consciousness of guilt, statements that Trump made in litigation, in his financial disclosure form, and even on Twitter that show he knew full well exactly what this was. It was a repayment for a hush money payment to Stormy Daniels, not payments for legitimate legal services.
So, Mary, that's a lot to pack into a closing argument. You know, a lot of what was in the opening, which was interesting, it was storytelling in kind of an edgy way that average people who weren't lawyers could understand. What is most important in your view in this closing argument that the jury needs to hear and digest and understand?
Yeah, a few things. I mean, he wants to continue the storytelling in the sense of, we've now told you this story. Here's the evidence, and I agree with Lisa. He'll set out a timeline, and he'll go through it chronologically. Here's the story that we told you in opening. Here's how we proved it up through the evidence that was admitted at trial. I think crucially as well, he will show how basically the government, the people, as they call them when it's in a state court in New York, the people established really the elements of this crime even before they got to Michael Cohen, so that he will try to minimize the necessity for Michael Cohen's testimony, Michael Cohen's evidence, and have the jury understand that the case was pretty much proven, and then Michael Cohen just tied it all up, filled in some gaps, but everything that was critical that he said that is necessary to find Mr. Trump's guilt had already been corroborated and proven through other witnesses, through exhibits, through Alan Weisselberg's notes on the the actual documents that were actually the bank records that Michael Cohen had, the notes about how the repayment would be made, all of these things. So I think that's going to be very, very important for him. The defense, on the other hand, is going to hammer Michael Cohen's credibility and try to suggest that Michael Cohen was acting completely independently. To the extent there was a conspiracy here, it was a conspiracy between Michael Cohen and David Pecker and, Keith Davidson, but not Donald Trump.
The Michael Cohen acting roguely just doesn't even make sense as a human being. But again, I'm not a lawyer. Glenn, I want to go to you because you wrote a piece this morning. It had a lot of interesting pieces in it. But as Mary just said, I mean, a lot of their strategy seems to be around Michael Cohen's credibility. And you basically argued in your piece that Michael Cohen admitting to his lies may help with the jury and credibility, right? He did admit to it pretty quickly. You also wrote about how you would handle the issue of the phone call, which was kind of a big moment during the last couple of weeks that Cohen may have mixed up in terms of the date or the content of it. Tell us more about that, your strategy and the Cohen piece of it.
Yeah, I agree that they will hammer on Michael Cohen. But the good news is, Jen, the jurors don't check their common sense at the courtroom door. They bring it into the jury box, they bring it into the deliberation room, and they're going to view the evidence through their sort of common sense lenses. And I think one thing that will likely resonate with them is the question, who benefited from this crime? Certainly not Michael Cohen. He wasn't running for office. He didn't get elected president of the United States. In fact, it sounds like he had to sneak around and hide from his own wife the fact that he was opening a home equity line of credit to make this, corrupt hush money payment. Why? To try to help Donald Trump win elected office. That is the kind of common sense argument that will resonate with the jury. With respect to the phone call, I frankly chuckled to myself as a former career prosecutor when I heard people, swooning over just how damaging that was to Michael Cohen's credibility. Think about this. Michael Cohen did not accurately remember whether he told Donald Trump in a phone call on a Tuesday or a Thursday, hey, boss, I made the payment. Now, first of all, I would ask the jurors, ladies and gentlemen, do you remember chapter and verse, the time of each phone call 8 years ago? You may remember the substance of a consequential call, but you're not going to remember the date and the time. And more importantly, as much of a cheapskate as Donald Trump is, do you really think he would have started writing $35,000 reimbursement check if Michael Cohen hadn't told him, hey, boss, I made the payment, I want my money? These are common sense arguments that will resonate with the jury. And I think the defense overplayed its hand in any number of ways, including, and maybe we'll get to this, insisting that Donald Trump had no sexual encounter with Stormy Daniels. Boy, is that going to come back to bite them.
That was such a strange part of I think it was in the opening statement of Todd Blanche, right, where they kind of insisted on that. Lisa, let me ask you about that piece, because it is this credibility component seems like it's a big weight for how both sides are thinking about the jury. And as Glenn mentioned, there's the did he or did he not have sexual relations with Stormy Daniels? But there's also this credibility of Michael Cohen. I mean, how do you play that if you're the prosecution?
Well, I think I would take Stormy Daniels separately from Michael Cohen. Let's talk about Michael Cohen first. I think the way you play that is, as Mary was suggesting, about minimizing Cohen and really focusing on all the other ways they've established critical facts, and chiefly through two people's testimony, David Pecker and Hope Hicks, each of whom were absolutely devastating to Donald Trump. So when you were talking about earlier, when Glenn was saying for whose benefit was this scheme, certainly not for Michael Cohen's, one answer to that is, of course it was for Donald Trump's, because why else would Donald Trump throw David Pecker essentially a thank you party from the White House in July of 2017, where he said to Pecker, according to Pecker's testimony, invite whoever you want. This is a thank you for you. Well, what the heck else is Donald Trump thanking David Pecker for, other than saving his behind in the general election by burying not only one, but two stories that could have had a devastating impact on his campaign in the wake of the Access Hollywood tape? In terms of Michael Cohen and his own credibility, the way that you shore up that credibility is similar. You show all the ways in which the documentation and other witnesses support Cohen. So, for example, Hope Hicks, by taking a dig at Michael Cohen, actually shored up his credibility. She said, I didn't believe for a second that when Trump was telling me Cohen made this payment out of the goodness of his own heart, that's the way that all went down. And when she was asked why, she said, because that wasn't the Michael Cohen I knew. The Michael Cohen I knew was the first person to take credit for anything. He was not a selfless and generous human being. That's the way you establish Michael Cohen's credibility, even if it means taking a knock at him in other dimensions of his life.
Yeah, I mean, the corroboration of it by so many witnesses is such an important component of this. So, Mayor, I feel like everybody this is the thing people are texting me is like, how long will this take? We don't know. Everybody's becoming a lawyer. So one of the things I read about is that the jury is not allowed to take the instructions with them, which I think it might be standard in New York. We could certainly ask Lisa that question, or maybe you all know the answer to that question. How do they do that? Do they take notes? Do they go in there? Is there any tea leaf reading you're going to be watching for their timeline of deliberations?
Yeah, and I think part of the reason that some courts decide they're not going to give the jury instructions to the jury is they don't want people who end up having questions and going back to it then playing lawyer themselves and interpreting that language. So the court wants, if there's a question about instructions, the court will want the jury to ask the judge their question.
And the judge will then talk to the jury
exactly.
again.
And that way it's coming from the judge. So they are going to be relying on memories. And you'll recall also that at the beginning of this trial, the judge allowed them to take notes. And another thing I expect that you'll hear in jury instructions is your notes are not evidence and your notes are not proof. Use them as an aid to refresh your recollection. But, you know, people should understand people make mistakes in their notes and don't rely too much on that because, you know, sometimes once people have written something down, they get very...
They take it as fact.
They take it as fact, right? But of course that's not the case. So those kind of instructions will be there for the jury. In terms of how long it takes, I mean, there's just no way of knowing. What they don't need to do, what you often start other federal trials with, is electing a foreperson. We already have a foreperson because it's just the first juror selected in New York. But they will go through, there are 34 counts, but the proof for each is going to be pretty similar, right? The instructions will tell them what elements they have to prove in order to find guilt. The people had to prove in order for them to find guilt beyond a reasonable doubt. I think in addition to the different alternatives you mentioned at the top of the hour about what the jury might do, there's another possibility too, which is a mixed verdict, right? It is possible. I'm not suggesting they should do this or that the prosecution didn't prove its case for all 34 counts, but they could view the first few counts relating to payments that were actually when the reimbursements were coming from the Trump organization, the Trump Revocable Trust, signed not by Donald Trump as president, but signed by those still working for the Trump organization. They could view those differently, for example, than the 9 counts where Donald Trump himself was signing from the White House, for goodness sakes, and where they've heard evidence that those invoices were sent personally to Keith Schiller to be brought over to him to sign. So you could see potentially some breakdown between some counts finding not guilty, or hanging on, not having all 12 agree, because an acquittal means all 12 have to agree. I find that highly unlikely, to be honest, in this case. But you could have breakdowns like that, and that takes time.
Yeah, that's an interesting, all things to watch.